technical. So it's about, hi, everybody on Facebook. It's Elektra. Yeah, just introducing myself again, artist, visa lawyer. We're going to talk about future work. And like I said, it's both substantive and also technical. Substantive in the sense that we've got to draft contracts to prove the work that you're going to be doing. And then technical as well, because it gives information necessary to inform the officer of your own validity period, things of that nature. But this very specific topic that I want to discuss about future work is with regards to what happens post approval. So if you have been following our videos, you know that O1s are divided into two separate sections. So the first section is O1A, and this refers to those who work in sports, athletics, science, education, etc. Typically used by people who file who are tech startup founders. And then O1B, this is for the artists. So the laws for O1A and O1B and the rules are not the same, right? What is applicable for the O1B world is not necessarily applicable to the O1A world. And one of the biggest differences with those two O1s is this idea of what happens post-approval. What happens when you are approved? Right? And you filed your O1, you've got your itinerary, you've got all of your work lined up for the next 3 years. What happens post-approval, right? So typically what happens to most people who work in the arts is they start to get more work. They start to get more offers because now that they have work authorization or proof of employment, people now are no longer so weary of wanting to hire them. So it is easier for them to get offers, to get gigs, to get jobs, et cetera, et cetera. But what happens with those offers? Can you accept that offer free and clear? Or do you need to take steps after you've accepted that offer to kind of remedy that new offer with the petition that was filed? So in the O1A world, yes, absolutely. You must file an amended petition if you want to accept those additional jobs, because the O1A does not allow for additional performances and engagements post-approval. It does not. You cannot. You can only file an amended O1 petition. Now, in the O1B world, you are allowed to accept those additional jobs, etc., gigs, future engagement, as long as, number one, it does not violate what was previously submitted. So for example, if you filed as an actor and then you want to accept a job as a makeup artist, you can't do that. Performing and serving as a makeup artist are two separate fields. They're not, you didn't get approved to be a makeup artist, you got approved to be an actor. So as long as those additional performances and engagements don't violate the field of endeavor that was previously filed, don't violate the professional title that was previously used within the petition, you can add those additional performances and engagements. You can add those additional jobs. And what is the process of adding those jobs? Lots of times clients will think, oh, I have to come back to Elektra. Oh, I have to inform USAS. Oh, I need to go to my petitioner. Now, the answer is very simple. Sometimes it's so simple, it's scary. You do not need to come back to me to file an amended petition. If we filed under a specific title in a specific field and you're accepting work within that specific title or that specific field, there's nothing that you need to do to inform USCIS, and there's nothing that you need to do to form your agent. Now, that is the law. In practice, what are the best practices in terms of what happens when you get a job post-approval? You should absolutely document that. You should document those new jobs that you have gotten, because that helps you be a little bit more organized in the work that you are doing post-approval, because the O1 has right? For example, USAS can conduct site visits, which basically means they can go to your place of employment or the different places that you have worked. USAS can call the jobs in your itinerary that was submitted within the petition. They have very broad investigation powers. It's not necessarily just, okay, you file the petition and you're done. They can reopen that petition or revoke the petition at any time. So it's good practice to save the information associated with the work that you have done. It is not legally necessary, but I think that you want to be careful and you want to, do the for yourself. And why wouldn't you save this evidence? And why wouldn't you save this proof, even though it's not a requirement of you? It's just a way to be scrupulous. It's just a way to make sure that you are crossing all your T's and dotting all of your I's. Again, it is not the law, but I think it's best practice to document and save all of that information, because yes, you might not get a site visit or a field visit, you might not get a phone call, but it will serve you for when you file for your extension. So to answer the question, this is a really simple question we can answer. Can I add additional work post approval? And the answer is yes, for O1Bs, as long as it doesn't contradict what was submitted within the petition, as long as it's within the same field of endeavor and within the same professional title. In the O1A world, you can't do that. You can't add work without filing an amendment, right? Because that additional work would be definitely considered to be a material change. So it's very important that when you are on your O1 journey, whether it's O1A or it's O1B, to speak with a licensed professional to be able to understand, do you fall under O1A or do you file under O1B? Because there are consequences to filing under O1A, because it is more limiting than the O1B. The O1B, as I've said multiple times, I reiterate this all the time, is based on your professional freedom, your ability to add more work. Just like somebody who is an American citizen or a green card holder who would not need to go through a visa process, right? You can add additional work on the O1B. You can continue to add work throughout your whole validity period without being scared of having to file a new amendment. So that is the beauty of the O1. That is the beauty and the uniqueness of the O1B artist visa. So that's why it's important to have a consultation to assess, if a petition can be filed under the O1B prong. Not all the time. Today I had a consultation with somebody who is a gaming expert. So not somebody who is gaming per se in the traditional sense, like not somebody who's creating video games. I have a lot of video game clients that we represent, that we file under O1B, but somebody who advises on how to win games. So that is very, very similar to like business strategy. And I don't think that the officer would accept that that is something that is artistic, which is why I advise the client, the potential client, this is not something that I think would be a viable case under O1B. So it's important to have these consultations, to have these discussions. So I hope that this was helpful. As I told you, I was back today to come and talk about future work. This is one aspect of future work. It's a pretty big aspect of future work. And tomorrow we'll talk about, I have something planned for our schedule tomorrow. I'm not sure if it's related to future work, but if we have enough messages related to work issues with regards to the O1, I'm happy to change my topic schedule and talk about future work and what that means, especially for those who are really unsure. And I know the rules and the laws are really complex to read, which is why I think these calls and these chats are really interesting and really important. It's your time to ask me questions on TikTok, on Instagram, on Facebook, on YouTube. I'm here to answer questions and provide information. But for legal strategy and specific information about your case, I cannot do that on a live. You'd have to call the office or email me to schedule a consultation. So I hope that this was clear. Hope this provided you a little bit of relief that post-approval, you don't need to come back to an attorney. You can add additional performances and engagements. And USCIS has actually published that information on their website. So it's publicly available information and widely known and accepted by USCIS immigration officers. So it's great talking to you guys, and I will talk to you tomorrow. If any specific questions, feel free to DM or message me or write a comment in the chat. Thanks, guys. Bye-bye.